Hey everybody, my name is Donny Dennison and I am an elder law attorney at Mandelbaum, Barrett in Roseland, New Jersey. And today I'm talking about a really exciting and pertinent topic that is the Blind Side actor Michael Oher and his conservatorship. I'm sure if you've turned on the news in the last couple of weeks, you've heard a little bit something about Michael Oher, the Blind Side, or his conservatorship, and the fact that a Tennessee judge most recently vacated a conservatorship that the Toohey family had over Michael Oher since he was about 18 years old. So in order to understand how he got to this point, it's important to understand a little bit about Michael Oher's history. Michael was deemed a ward of the state of Tennessee at the age of 11. And after that point, it's my understanding that he was more or less couch surfing on friends' couches. A friend of his father, helped Michael get into school. And then around the age 18, Michael was introduced to the Toohey family, a husband and wife in Tennessee, who offered Michael to stay there permanently. Shortly after Michael's 18th birthday, the Toohey family told Michael, allegedly, that they were going to adopt him. And shortly after that message was conveyed to Michael Oher, they presented Michael with paperwork. And that paperwork, we later found out, was paperwork to establish what's called a conservatorship. I'll talk about that in a minute. But it was not adoption paperwork like Michael thought it was. And so Michael thought, up until very recently, that his adoptive family was this Toohey family in Tennessee. Michael alleged in his pleadings to have the conservatorship removed that the Toohey family held themselves out not only to him, but to the community at large, that they were his adoptive parents. And Michael says that that was the furthest thing from the truth. But what is a conservatorship? You know, a conservatorship is a little bit different depending on the state that we're talking about. So I'm sure a lot of people have heard about Britney Spears and her conservatorship in California. In fact, I think we've done a previous video about the Britney Spears conservatorship and what that meant in California terms. In New Jersey, a conservatorship is very limited to financial decision-making, and it requires the person for whom a conservator is established to consent to that conservatorship. So someone maybe who has difficulty managing their finances would consent to a conservator being appointed to help with, the monthly bill pay or managing a savings account or something along those lines. In Tennessee, it was a little bit different for Michael. In Tennessee, a conservatorship was a little bit more like a guardianship that we have in New Jersey, where the person or people appointed to serve as the conservator or co-conservators have very broad decision-making authority over their ward or over the person to whom a conservator has been appointed. And so the Toohey family, in Michael's case, had very broad decision-making power over Michael's life, health, finances, etc. More importantly, the Toohey family had the ability to enter into, negotiate contracts for Michael, which they did in fact act upon, and which caused Michael, after learning that the Tooheys were not his adopted parents, but in fact his co-conservators, to sue them, claiming that they not only mismanaged his funds, but also took what he claims to be millions of dollars that he should be entitled to by virtue of being the star of The Blind Side, the book, and the movie. And so the basis for the suit was twofold, really. One was to have the conservators removed, which a judge recently granted in Tennessee, but the other portion of Michael's lawsuit is alleging that the Tooheys, who were his conservators, breached their fiduciary duties not only of loyalty to him by self-dealing, by providing themselves with his money, but also by not accounting. Each year in New Jersey and in Tennessee, a person who is appointed as a fiduciary, someone who is appointed by the court to manage the finances of another, has a duty to account for the finances that they're managing. Michael's lawsuit claims that the Tooheys did not do that. In fact, he says he never saw an accounting once from the Tooheys, and court papers confirmed that was in fact the case. And so Michael is alleging in this second part of the lawsuit that he was never treated fairly by his conservators. On the other hand, the Tuohys are arguing that they were acting in Michael's best interest and that they did make distributions to Michael of what they consider a fair share of what Michael was entitled to under the various contracts that they entered into and negotiated on Michael's behalf. So the court has not made a decision with respect to Michael's other claims, but we did recently learn that the co-conservators were removed, and that brings up the topic of conservatorship and guardianship, something that we in the Elder Law Department at Mandelbaum Barrett handle frequently. Frankly, guardianship is a lot more utilized in New Jersey than conservatorship, but conservatorship does have its uses in certain limited circumstances. But in any event, if you or a loved one have any questions about conservatorships, guardianships generally, feel free to reach out to us. We're always here to help out. Thank you.